is 6 p.m., Thursday, March 4th, 2021. I'm going to get this meeting going. So my name is Carl Granrath. I'm the hearing examiner this evening. And the purpose of this hearing is to allow me to receive evidence and testimony on the matters that are pending. So I make a recommendation to the county commissioners. I do not make the final decision. And I will be submitting my recommendation to staff within 2 weeks of tonight's hearing. And then the application will be scheduled for deliberations before the county commissioners. So if you wish to give testimony, I see you filled this out, so I'll let you know when the proper time for you to speak is. And if we end up with anybody else online, doesn't look like we have anyone else on there, I'll let them know. So first of all, for procedures, staff is going to introduce the application, and then we'll hear from the applicant. And after the applicant's testimony, we will we can have comment from the public. So depending on if and when we have other people, I'll go through the procedure when we get there. So after the staff's presentation, the applicant can have up to 30 minutes. And if there is public testimony, those are limited to 5 minutes each, and the applicant can then have another 15 minutes to rebut any thing they want to that has come up from the public testimony. So, and just one final thing as well, all of your testimony and questions, I'd like you to direct them to me, not any other members of the audience. And if there's no other questions, we will get started. Okay? All right, so I believe we have Mr. Finkel to present the staff report. So go ahead.
Good evening, Mr. Hearing Examiner. For the record, Black Finkel with Kootenai County Community Development. The request tonight is case number DAR 20-0014 by Mr. and Mrs. Carter. This is a variance request to the minimum lot size requirement in the rural zone. The subject parcel of land is located east of Coeur d'Alene and north of Little Lodge Bay area. The zoning, as I stated, is rural with a minimum requirement of 4.5 acres net and 5 acres gross. The gross acreage is accounted by half of the right-of-way width adjacent to the property in question. Based on the current parcel map and assessor's information, the subject property is shy of 4.5 acres net. It's 4.25 acres in size and approximately a quarter of an acre less than what the county would consider to be a legitimate and compliant parcel in the rural zone. The existing parcel of land does have a residence and existing structures on it, and therefore this is not a newly created vacant site. When staff solicited comments to the variance for a minimum lot size requirement in the rural zone, agencies with jurisdiction had either no objection or were recommending approval of their request. I'd like to start with stating that when we solicited comments from adjacent property owners, we only received 2, and both of them were in support. However, I did get a call from the adjoining neighbors requesting clarification as to the reason why the request was being made. And I'd like to explain that this request is very unusual and perhaps unique because we rarely ever have a request to a minimum lot size that the county staff would support, simply because we don't want to promote or condone folks splitting parcels not in compliance with the regulations and asking for forgiveness or asking for them to be legitimized in order to obtain permits and other development allowances on the property. However, in this case, when Mrs. Carter contacted the department, staff had a pre-application conference to discuss the need for a variance. And what we were advised of is that when the applicant recently purchased this property within last year, they were not aware, and it was not brought to their attention by the seller or the real estate agent, that there was an issue with the property being considered non-compliant with the current rules and regulations. It was only when they requested a building permit to renovate some of the existing structures on site, that they were advised by our front desk planners that unfortunately, the county could not issue any development permits, including building permits or site disturbance, simply because the site was considered to be non-compliant. And here's the reason why. In 1992, based on a research conducted by staff, the previous owners, almost 30 years ago, split the property out of the larger piece. And up until November 17th of 1995, the Kootenai County residents did not have to go through any subdivision review in order to create parcels. However, they had to meet the minimum requirements in the underlying zone for those parcels to be considered legitimate. So the split was done, in our view, not in compliance with the minimum lot size requirements, although it didn't require a formal subdivision review. And therefore, we initially spoke with the applicant to see whether or not they could acquire additional land. However, it also presented a challenge because, as you can see on the zoning map, at least two boundaries, or at least two property lines are bound by the right-of-way, and therefore there's no additional land to acquire. And the applicant then advised staff that they attempted to acquire land from the adjoining parcels to the parcel owners to the west and to the north. Unfortunately, either those individuals were not willing to sell a portion of their property to bring this property up to the minimum lot size, or they requested a significant amount of money that the applicant could not afford. Their only option was to request a variance to the minimum lot size. And because of the conditions that the applicant was put in, purchasing the property, and finding out almost 30 years later that an issue did exist and it was done by somebody else, staff felt that we could support this application because the applicant had undue hardship, that they could not receive or request an approval of building permits simply because they didn't have additional land to account for the minimum lot size in the rural zone. And so the code under section 88203 does contemplate a variance to the minimum lot size. And therefore, we believe that approval of this request would not constitute an adverse impact, or I'm sorry, it would not create an undue impact, a hardship on the adjoining parcels, but it would give the applicant an opportunity to seek building permits on this site in order to renovate the existing residence and other outbuildings. That concludes my brief presentation, and I stand for any questions that you have at this time.
Yeah, can you just repeat for me real quick? I was trying to take down notes. You said in 1995, perhaps an ordinance was put in place requiring, a division like this to be recorded or go through, Kootenai County. Can you just repeat that part of your explanation again, please?
Absolutely. Pursuant to Kootenai County Code, the cutoff date for folks being able to create a parcel through recordation of deed was up to November 17th, 1995, as long as the newly created parcel met the underlying parcel size requirements, which in this case, it was in the rural zone, and the minimum lot requirement had to be 4.5 acres of net and 5 acres gross, accounting for half of the right-of-way that abuts the property in question. Everything after November 17th, 1995 had to go through a formal subdivision process. So the previous property owners quitclaim deeded this property as 4.25 acres to somebody else, not the current applicant. And at that time, it's not clear whether they were aware of the minimum lot size requirements or not, but the fact of the matter remains is that through our research, the 1992 deed, while it created a property that was at that time an allowed process, it did not meet the minimum lot size, and therefore the current status of this property is non And our code states that parcels that are non-compliant are ineligible for building or development permits such as site disturbance, or flood, permits. Floodplain permits, sorry.
That was great. Thank you very much. That's the only question I have for you. So now we'll go to the applicant. If you would like, you have up to 30 minutes to make any presentation you'd like.
Yeah, I just wanted to thank you all.
Please state your name real
Oh,
quick.
my name is Ginger Carter,
Okay.
and we purchased this property January 28th, 2020.
You really have to be right on top of it.
There you go. All right, and I just want to thank you all for being here and listening to this. We had no idea that we'd be in this situation when we bought the property. And I really don't have much to add to that, except that we bought this property to retire in, and we wanted to fix it up and restore the farmhouse and the property, bring life back to it. As you know, it's sad. I think 30-plus years with not much done to it at all that we can see, and so it needs repairs. And so without this variance, we're unable to make that a house to live in. So I'd appreciate anything you can do to help us in this situation. We did contact the neighbors. We met our both adjoining neighbors, and one refused to sell anything, and then the other one knew our need and, by our surprise, asked for way too much money that we could afford to just get a quarter acre. So here we are. I'm just really thankful, though, that when I contacted Kootenai County and the planning department, that they gave me hope that, you know, I didn't waste our retirement money and all our money on buying this property, and that we can live here someday and we can fix it up. So I really don't have anything to add, except that, you know, we just would like to fix up the home to a livable condition. And there was a shop in the back that was ripped down, that the foundation's still there, and possibly, you know, do some work on that. Anything else? Do you want to ask me any questions?
No, actually, I have no questions for you.
Yeah, no, I'm just excited that this is an opportunity to let myself be heard. We appreciate it.
Okay.
Okay, thank you.
Well, thank you very much. And as you were the only member of the public who wanted to comment,
And there's no one on Zoom other than staff.
okay. Well, with that, then, at 6:13, I will call this meeting to close. And for variance 20-0014. And that's it. Everybody have a good night.